Welcome back to another episode of Get the Guac, and today we are joined by Emily Lashley, the managing partner of the Towson office of Whiteford, Taylor, and Preston. Emily is a very knowledgeable expert attorney, and she's also my attorney that's helped me with all of the business and real estate things that I've done. So I'm excited to have Emily here. She has a very diverse legal background, helping people with estate planning, real estate, business, law, and so on and so forth. So thank you for coming in and joining.
Thank you for having me today.
Absolutely. So Emily, give us a little bit of your background. How did you become a lawyer? Was it something that at the age of 2 you were just drawn to and knew that's what it was going to be?
If only. No, I actually spent a long time trying to figure out what I wanted to do. It was to the extent of my senior year in college, I had not declared a major.
Okay.
And so I finally went to the wall at Towson University that had every major listed in a pamphlet. The wall probably doesn't even exist anymore because nothing's on paper.
And younger viewers would say, what's a pamphlet?
Precisely.
Right.
And I just flipped through, and I'm drawn to logic and practical situations and reality, so things that make sense. And the pamphlet that had the most classes that made sense to me and were the most logical was something called Law and American Civilization.
Okay.
So I ended up going that route, and what are you going to do with that besides go to law school? So
Right.
That's where I ended up, and here we
where
are.
did you go to law school?
I went to the University of Baltimore.
University of Baltimore, all right. Now, career-wise, so you passed the bar, you're now practicing, and you have a logistical letter of the law kind of mind or lean. And while the law is the law, you have all these people and personalities.
Yes.
Was that interesting? Did you expect that? Did anybody tell you that, yes, the law is the law, but these personalities are going to make it interesting and maybe sometimes fun, maybe sometimes frustrating?
I wish they had. No, it's something that we sort of pick up and learn as you go along. There are so many different areas of law, hundreds of different practice areas.
Right.
And to the average person, they think, you're a lawyer, great, you know the law. Well, sort of, but there are different codes and code sections and different articles within Maryland law, and they all have books that are inches thick that tell you what you can and can't do. Mm-hmm. And each one is a different practice area. And I started my career at a smaller firm, so we did a lot of different things. And I moved to Whiteford about 17 years ago, and I have surprisingly narrowed my focus to the 4 or 5 different areas of law in which I practice now.
So for a lot of folks that we work with, and that you've worked with some of our clients in the
Yep.
past,
Yep.
who've been very happy, estate planning. Estate planning is very confusing. I think it's very sensitive because people feel like if they put a plan together, they're going to die the next day.
Yes.
Do you ever get that?
Yes, I do. It's one of those things that's on everyone's list of things to do, but they don't want to do it. Parents with younger kids find it sensitive because, who in the world could take care of their children as well as they can? And I've had clients, have phone calls with me or meetings in tears just thinking about if they're dead, who's going to take care of their kids?
Right.
That's the big ticket item that I think causes the most delay in getting everybody in the door.
What do you think helps kind of take the pressure off that emotional response when it comes to end-of-life planning?
For me, I have kids. I have a 13-year-old and an 11-year-old, and that helps them because I can relate to what they're talking about.
Right.
And I'll, give a little bit of examples on things that I've done, things that I've come across, either personally or with other clients, obviously without disclosing names.
Right.
And just let them know that it's okay. It's normal. It's perfectly fine for you all to think about it, take a little while to get back to me before coming up with the final plan on what you want to do. And I try to make it as relaxed, and strangely enough, I make jokes during our conversations.
Oh, humor's a great tool, I think.
It's really the only way to get through it because people, when I see they're starting to get upset about something, I'm like, hey guys, we're all dying. It's going to happen.
Right.
Better you first than your kids first. So let's move forward with that. And they're like, oh yeah, good call. So, and the ultimate point is you have to take care of your things so that people aren't left after questioning what to do, how to do it, who's going to be in charge, who's going to take care of these things. You don't want your kids fighting or your family fighting. If you've got something in place, they don't have to worry about it.
What is the right time for folks to really consider getting proper estate planning done? What phase of life?
At any time they have something, assets.
Right.
Certainly if you get married, absolutely if you have kids, because the big ticket item in your will is a guardianship. So it sets out where you want your kids to go, who you want to take care of them, It's not a play-by-play list of what to do. It's not a script, but it's guidelines or guidance for the people that are going to be left in charge of your kids. So definitely business owners, if you have a business, you work so hard to build something, you don't want it to be left in the dust if you pass away.
Right. So maybe, just to oversimplify things, graduating college, it's not super critical. Don't put it to the top of unless you have kids, but if you're your typical single, trying to get my first job, I'm renting an apartment, not a huge need for a will.
Probably not a will. I would suggest a power of attorney just to put somebody else in place in case something happens to you, something you need to do something. If you get into a car accident, you're in a coma,
right.
You're traveling overseas for something and you have to address an issue back home. If you're not around or you're not able at that point in time, you should have a backup person to help you out.
So let's go into that a little bit. So a power of attorney, would it be a springing power of attorney? Or is this power of attorney in force and your parents can make decisions on your behalf still?
It can be either way. What the power of attorney that I typically do is a general durable power of attorney. It essentially allows it's called an attorney in fact, which is like an agent. Doesn't actually have to be an attorney.
Right.
But it's an agent that you have selected and appointed to take care of something in the event that you cannot, or in the event that you don't feel like it.
Right.
If you don't want to go meet with your financial advisor and you say, Mom, can you just go? I can't stand meeting with this guy.
Right.
Mom can go and sign things.
Dentist appointment?
Yes,
right.
yes. And so certainly you want something in place in the event that something really does happen. If you're in a car accident, in a coma, you still have things to address, your rent,
Right.
Bills that need to be paid until you can recover. Or if you want to travel overseas as part of a class or something along those lines, you still have responsibilities or things that need to be addressed at home. Someone can be put in place in the event that something happens. You get a letter from the landlord. Landlord won't talk to you if you're not on the lease. So
Right.
That's where the power of attorney comes into play. And mine they are effective immediately. They can be withdrawn at any point in time by a written notice saying, hey, you're no longer my agent.
Right.
But it is effective right away, and it gives the person kind of the ability to stand in your shoes.
Interesting. I hadn't considered that.
Yep. And you can also structure them so that they only come into play in the event of a disability, an accident, if a doctor says, look, this person is incapable. Exactly. The beauty of them is we can draft them to say whatever you want.
Yeah. So early in life and next phase up, not for everybody, but for some folks, getting married. Is that will time?
Yeah, I think it would be.
Maybe buying your first home. People are kind of doing it in reverse, where maybe they buy a home before they get married.
Yes, I see a lot of that now.
Are there any legal considerations for that group of people?
If you are buying a home in your own name before you get married, there's not really anything to consider at that point. The tricky times arise when an unmarried couple buys a house together and then they break up.
Right.
And then there's a huge battle over who paid the electric bill the most, who paid the cable bill the most, and who put the most money down. And it's a numbers fight, but it's a fight. Somebody may have been in school while the other person was working, and so that person contributed a little bit more, but this person was home and cleaned and cooked and did all of those things. So that is when it becomes difficult. So, I don't advise one way or the other, but I let you know if you're buying a house and you're not married, there's no law in terms of how it gets separated, really.
Right.
Especially if one person wants to stay and the other one doesn't.
Yeah.
And nobody wants to sell it, but they can't afford to buy each other out.
It just gets tricky. Is that
Very
a
tricky,
legal
yeah.
term? Is that from University of Baltimore?
Yeah, it's in Black's Law Dictionary, tricky. Right after that it says call Emily Lashley.
That's right. Now, once kids come, it's will time.
It is absolutely will time, yeah. If you have not done it already, it absolutely is, just so that you can provide for their protection.
Right.
The will talk about who the personal representative is, and that's the person that, make sure whatever you've said in your will actually happens. They're kind of, think of it as a company. If you pass away, your estate is sort of like a company, and you need a president to be able to sign off on behalf of the estate. That's like a personal representative.
So when we get a will, we're picking an executor. What are the qualities we look for in that executor?
As someone we trust, someone who's responsible, someone who they don't need to understand how it works or what to do necessarily, but just somebody who is has an ethical background. That's what I would say. Someone who you trust to take care of yourself and make sure they're going to do it correctly.
And then let's say, so in my estate documents, it could be different, the person that handles the estate, the executor, versus the custodians and guardians of the children.
Yes, absolutely.
Do you want checks and balances where someone's in charge of the money and someone's in charge of the welfare for the kids, or how do you recommend?
So I actually recommend the other way around. So your personal representative has a role, and once your estate is kind of finalized and assets are distributed, they're done, they're finished, they get to go on their merry way.
Right.
A guardian is going to be the person in charge of making sure that the kids are fed and clothed and have shelter and get to school and
Raising them, basically.
Exactly,
yeah.
raising your kids. And then there's a separate person, or could be a number of different people, a trustee. And it doesn't need to be like, Taylor Swift trust fund. It's just whatever assets you may have had, like bank accounts, some investments, maybe a house that was sold, that money will go into an account in the name of a trust for the benefit of your kids.
Right.
Now, I have seen, and I've done wills that have one trustee versus a different guardian. I actually did a will for a friend, and she said, my brother is amazing with kids. I want him to raise my kids if something happens to us. He's terrible with money.
Yeah.
I can't have him in charge of the money.
Right.
So she's had different people. The flip side of that is, if the guardian and the trustee are different, you certainly don't want them butting heads over something like private school, for example. The guardians may say, look, the school in this neighborhood is really going downhill. It's not great. We need money to send the kids to private school. There's enough money.
Right.
Well, if the guardian is not the trustee could say, look, I went to public school. I did fine. Everything's fine. Just send them to public school. I'm not giving them money for that. And then it's a battle that the kids don't need, that the
Right.
guardians and trustees don't need. So it's provided that you're comfortable with the guardian also being in charge of the money.
Mm-hmm.
If you don't have my friend's situation, then it's probably simpler to have them be one and the same person.
Yeah, and you mentioned a trust, and
Mm-hmm.
I am, from the financial advisor point of view, we have a whole bunch of trusts that we help folks manage, and it seems like they are overprescribed, in my opinion. Now, it seemed like they were also more popular back when the estate limits and try to get that maximum marital exemption.
Mm-hmm.
And a lot of people watching, they probably don't know what I just said. Can you explain kind of how, like, the purpose of marital exemptions when the limits were lower?
So I'll talk a little bit about the trust concept for the will, and then
Okay.
maybe I can get into that side of it. I almost rarely do any marital exemption trusts anymore, just because it doesn't make sense to do them, especially if spouses are growing up together. You rarely see a situation. It's not completely uncommon, but it's more rare now than it used to be, where spouses aren't contributing equally at some level, maybe not financially equally, but equally at some level to the upbringing of the family and just sort of the estate, itself.
Right.
So when I talk about a trust within a will, it's primarily for children who are under the age of 18. In the eyes of the law, even if you have a Doogie Howser kid, and for the new guys, it's Doogie Kamealoha from the Disney Channel. But even if you have a very smart, intelligent, perfectly capable 16-year-old, in the eyes of the law, that person lacks the mental capacity to handle the inheritance of money,
Right.
whether it's $100 or whether it's $100,000 or $100 million. It doesn't matter.
Mm-hmm.
So it has to go into the hands of a trustee and in a trust. And when I say trust, I don't mean it needs to be another 57-page document. It's a couple paragraphs within the last will and testament that says, hey, if I have someone that's under 18, their money should be given to the trustee to be held in trust. If you have one child, then you just open up a bank account, and it's literally called, we'll use mine as an example, Trust U/W, so under will of Emily Lashley, FBO, for the benefit of, and then the child's name.
Okay.
And that's the name on the account, the money goes in there. And the will talk about distributions. If the child turns 18, they can have everything all at once. Or there can be provisions like 25% when they turn 18, 25% when they turn 25, and the rest when they turn 30. And those are called mandatory distributions. The trustee has to give them that money. In the interim, the trustee has discretion to then be able to say, all right, you need a car to go to and from school because you have a job after school. I can't get there at 2:15 to pick you up. Let's get you a nice Honda Civic.
Okay.
And so those are the things that when I say trust under a will, that's really what we're talking about. We're not talking about a completely separate document.
Right.
And it's mainly so that, the money can be given to the kids and be used for their benefit. Otherwise, a court would require an actual legal guardian to be appointed, guardian of property to be appointed.
So I'd say we have, we'll keep going up. So young kids, now the kids are older. Out of the house, off the payroll. Well, they're never usually completely off the payroll. But
Fair enough.
college is behind you, all that. And it's time that we review these things. It's been a few years. Let's get our estate. Let me get Joe off my back. He keeps talking about reviewing my estate documents. When is there a need for a trust? And I know that's a broad statement. It's very circumstantial. But what are some things where that says, hey, a trust would probably work here, and one where you don't really need it? What are some situations that would lean trust and lean not trust?
So situations leaning to a trust are to really avoid probate. It doesn't save you in taxes. It just keeps property out of probate.
So a trust does not by itself save you taxes?
Not really, no.
Isn't that one of the common misconceptions you see all the time? I know I do.
Yes. There's an exception to that rule, but it goes along with avoiding the probate process. And that's really in the state of Delaware, for example. I know we're in Maryland, but in Delaware, if you pass away, you are heavily taxed on the assets that you own, the value of the assets that are in your individual name at the time of your death.
Okay.
So a lot of people who live in Delaware, who retire and move to Delaware, they put everything in a trust, because when they pass away, nothing changes. The trust still owns those assets, and therefore they're not subject to that probate tax. In Maryland, the same kind of concept exists, where if you pass away and your house, for example, is in your individual name, now it belongs to your estate, and we have to go through opening up an estate with the Register of Wills in the county that you live in, and go through the whole administration process. You can sell the house in the interim, but the funds can't be distributed. So I would say putting something into a separate trust as you get older, especially if you're thinking, okay, this is where we're going to retire, this is our forever home at that point in time, unless we move to a retirement community, this is where we are. So you put the house in the name of the trust, and that's simple. You just do a deed, very easy to do.
Any transaction
There's
costs, or you got a whole refi type of
Nope.
fixed?
Okay. It's a $65 recording fee, and that's it. So you'll be all set. The owners typically stay on as the trustees of that trust. It's a revocable trust, so they can take it out, change it if needed.
Different than?
An irrevocable trust, which means once it's there, it's there. You can't do anything about it.
There's no whoopsies, I don't want to do that anymore, it's done.
Absent a court order, yes, it's
okay.
done. I mean, there's always a way to get a court order.
Right.
But for the most part, for all intents and purposes.
If I change my mind and this guy's green the next day, and I'm like, I want to take my money out of the revocable trust, I can do that. With an irrevocable trust, it might be possible, but you're jumping through a lot of hoops.
Yeah, it's not something that's completed overnight either. It's going to take a while to get to that point.
Yep.
So you put things in the name of a trust. That way, if you pass away, nothing changes, because now the trust, it's like its own little entity all by itself. The trust itself is, the owner. So if you die, nothing changes. The trust still owns the property. The
Right.
trustees change. And then there'll be provisions within there that says, okay, here's what happens now that we've passed away. Our successor trustee is instructed to do the following.
Would a TOD designation or transfer on death avoid probate and some of those costs that you mentioned with Delaware?
Absolutely. So if there is an account, for example, at a bank that's jointly held, that avoids probate, because whoever the joint owner is, it automatically belongs to that person. Even if they contributed $0, it now belongs to them in the eyes of the law. Same thing with a pay on death beneficiary account, transfer on death accounts, life insurance policies, retirement plans, even investment accounts. If you have a beneficiary listed, automatically the money or the funds, the asset will belong to that beneficiary that you've listed.
Okay.
Whether you have 4 people listed or 1 person listed, it now belongs to them. It avoids the whole probate process. If you forgot about an account or set something up before you were married, before you had kids, haven't thought about it since then, and there's no beneficiary listed, then those funds just get paid into the estate, and they have to remain with the estate for 6 months. You
Okay.
can't transfer anything out for a period of 6 months once the estate's been opened.
I want to talk about estate planning pitfalls.
Mm-hmm.
Mistakes that people unknowingly typically make. And it's kind of a rapid fire.
Okay?
Changing your will after a divorce, does that change everything about where the money's going to go if you were to pass away? So, former spouse, divorced, remarried, I get a new will, but maybe I don't change designations on my retirement plan at work.
So the will is the catch-all. It's kind of the basket that is there just in case other things are forgotten about. So
Right.
what the other items, the accounts, the retirements, the 401ks, the life insurance, the banks, all of those kind of take precedent over the will.
Right.
And the will only comes into play if there is an item or items, assets in your individual name at the time of your death. With those pay on death accounts, when you die, those funds belong to someone else. So they're never part of your estate, which means the will does not come into play. So you can change your will, but you absolutely must change the other beneficiary
So if my
designations.
former spouse is the beneficiary of my 401k for the same company I've been for 30 years, I've remarried, I've been happily remarried for 25 years, I die.
Yeah.
Technically, the former spouse, if I haven't updated the beneficiary from the beginning, would get all of that money legally entitled to it.
Yes, and I would say lucky you're dead because your new spouse would be really angry with you.
If I wasn't already dead, I definitely would be when she finds out.
Precisely.
I want my kids to get my house, so I'm going to put their names on the deed.
Okay.
What's wrong with that?
Well, what if you want to move? And
Right.
your kids don't want you to move, or they want the house. Now you have to go through a court proceeding if you want to sell and they won't agree to it.
Right.
And because they're on there, they would then be entitled to a percentage of the net proceeds if there's an order to sell the property.
As a result of maybe one of the kids is a messy divorce, that property could potentially be included in the assets that get divvied up.
Absolutely. Because
The other thing, it's kind of tying into tax, is a step up in basis.
yes.
Mom and dad bought the house 100,000 years ago for 10,000 bucks in Buffalo nickels, maybe. Now the property's worth maybe close to $1 million. So there's a $990,000 unrealized gain that if the kids are on the house, it starts to chip away at the step up in basis.
Correct.
If we don't put the kids on the deed, then when they inherit the property, that basis, or what the tax looks like, resets
Correct.
to the value of the date of death.
There is a loophole that would help, though.
Okay?
If you don't put the kids on the deed, then when you pass away, that property becomes part of the estate and has to go through the probate process. Not the end of the world. It's
Right.
just not instant. You could do what's called a life estate with powers
Okay.
or a life estate without powers. A life estate with powers means you own the property, you can do whatever you want with it, you can sell it, you can lease it, you can refinance it, you can do whatever you want. And then immediately upon the death of you, and if it's, you own with your spouse, you and your spouse,
Right.
then it automatically belongs to the kids.
Yes.
And the value is your date of death value. So they get that step up in basis.
So it does step up.
Yes.
The difference could be hundreds of thousands of
Hundreds
dollars
of
of
thousands.
tax.
Oh, absolutely, yes. So that's the way to go. You don't want to really just put them on as joint owners. The life estate without powers means that they have what's called a vested interest in the property. They're not actually owners, but you can't sell it, you can't do anything with it unless they sign on and agree to it.
Okay.
So it's important to specify within the deed whether it is with or without powers, because if it's without, you lose your ability to do what you want to do with the house. But in either scenario, with or without, you're using the date of death value as when they, in terms of when they got ownership.
Let's shift gears to starting your own business.
Okay.
It seems to be a conversation I have more and more over the years. LLCs save you taxes. They make your breakfast in the morning. They do all these amazing things, right? It's like the super entity. What do LLCs actually do And why would we consider them when starting a business?
They provide you a layer of protection. Think of them as a mosquito net that completely covers you. If you are covered in this mosquito net, you can walk outside at night and the bugs can't get you. An LLC acts in a similar way. A lot of LLCs I form deal with people owning their business, whether that's real estate and they're buying property that they're going to rent. If they are, starting a franchise or working with a franchise company to start their own business in various different places, it provides protection from your personal assets.
Yep.
So, for example, if you are starting a business in real estate, you're going to buy a couple of houses in Baltimore City and you're going to fix them up and then rent them out. If it's in your individual name and someone at the house, slips and falls and gets injured, or there's a problem with the house, let's say there's lead paint that somebody missed, and they're suing you individually, which means everything that you own in your individual name is subject to that claim. They can grab that, they can tack on bank accounts, they can sell your house in order to pay off a judgment that might be earned.
Okay.
If it's in the name of the LLC, your liability, so LLC stands for Limited Liability Company, your liability is limited to what that LLC owns. They can't touch your individual assets. So if the LLC only owns that row house in Baltimore City, worst case scenario is that house has to get sold and the money is used to pay a person's judgment, assuming they win a case.
Right.
So it completely protects your family, it protects your assets, and so it gives you a little bit more control over what ultimately happens, and you can almost put a cap on your worst day.
It seems like there's some badge of honor of I own 5 LLCs. The drawback of LLCs, you're paying $300 a year in the state of Maryland.
Yep.
Every year per LLC.
Exactly.
So if you own a $100,000 row home in Baltimore that you're renting, and you have an LLC for each one, you own 10 of them, that's $3,000 a year right off the top.
Exactly.
Is there a general guideline of when it's time to open new? Is there a dollar amount for every $500,000 of real estate, or $1 million, or any kind of guidelines with how many LLCs make sense for the situation?
It's really almost a case-by-case basis, because if you have, 5 LLCs and, that own townhouses and they're each worth $100,000, okay. It's not a tremendous amount of money, but the more assets that LLC owns, the greater the potential liability in the event something goes wrong. Right. I mean, most of the time it's almost like an insurance policy. You're carrying insurance just in case. You have these separate LLCs just in case. So you kind of weigh it, all right, do I have significant personal assets that I absolutely don't want to intermingle with my LLC, have something separate, or, if there's a scenario where something does go terribly wrong and you need to come up with funds, A, you have insurance for things like that for the most part, and B, I would say, it really is a case by case. I would say keep it limited to whatever dollar amount you might be comfortable with. Like if you don't care that the liability is now at $500,000 because you own 5 houses, okay, fine. But if you want to keep it limited because it's maybe a rougher neighborhood, or because you've had bad experience with a couple tenants in the past and you just want to, keep everything separate. Mm-hmm.
The attorney and the insurance expert coordinate to limit that exposure, right? There's a lot of overlap between the two. There's
a little bit. I mean, I don't necessarily interact directly with the company, the insurance provider. I do have folks that I recommend to some of my clients who are looking to get insurance for their LLC and they may not know where to go. Mm-hmm. And so I have names that I give out, but and I kind of almost defer to the insurance agent because they can find the best policy for the best price for this person. But I say, look, here's what I tell the client what they need to tell the insurance agent. I have this row home. I'm going to be renting it, but I'm not going to have it up and ready to go for another 6 months because I need to make it into a shell and then completely rebuild it from the ground up. Mm-hmm. So the insurance agent would then be able to say, all right, well, you have vacant insurance right now, then you have renter's insurance, like for tenants who are going to be in there. And so they'll be able to get the best policy
So LLC with proper insurance coverages and a big fat umbrella liability policy on top of it.
Yep.
That should cover like 98, 99% of most people.
Yes.
Yeah.
Yes, I would agree. And a lot of times, just to tack on a little bit, what people do, if they're going to have multiple LLCs owning multiple different properties, they form one LLC and it's like a holding company. So instead of them individually owning each LLC, they own the one, Joe Conroy Holdings LLC. You're the owner of that company, and then that company will own all of the different LLCs for each
LLC 1,
property.
LLC 2, one has the property, one has the business.
Exactly. Or one,
Interesting.
each one has a property, and then the insurance policy can be there and cover everything else. And that might be more cost effective, but that's where I would defer to the insurance agent. Like, is it better to have the policy
Right.
here at the holding company LLC, or is it better at these individual guys?
I'm working with a couple who are exploring very real possibility of opening a franchise.
Okay.
So we're having some of these conversations, and they said something where I don't want to be the smartest person in the room, right?
Yes.
I want to be able to run this business, and I'm leaning on the experts, the advisor, the role I fit, the attorney, insurance coverage. And not that everybody has to be in the same room at the same time, but everything's coordinated, and there's some level of communication and coordination.
Yes. Yes.
So I'm going to start a business.
Yes.
I'm going to buy a franchise.
Okay.
Step one, do I open my LLC and then I go to the bank and I get a checking account in the name of the LLC, and then I invest into the franchise and I coordinate with insurance? Like, what's
does that
kind of
look
the
like?
timeline of things?
Step one, call Emily.
Yes.
Step two, what we would do in a situation like that is we would take the steps of forming an LLC, which is filing the articles of organization. It's going to be in Maryland. You want to have it in Maryland. Then we would do an operating agreement, because if you're buying into a franchise, they're going to want to see the operating agreement. That's an internal document. It doesn't get filed anywhere, but it talks about who the owners are, who has authority to do what, who are the managers of your LLC.
Right.
And it could be just one person. That doesn't need to be multiple people. Talks about the ownership interest. Is it 50-50 if it's two people? Is it 75-25? Or one guy, 100%.
Right.
And then we get a tax ID number for you so that you can go and open a bank account, so that, again, everything is separate from your individual assets. And if you're going to be opening a franchise, you absolutely want to have it separate anyway. So once those documents are formed, then you go to the bank, you talk to the bank about what you're going to do, what you're going to need to buy into this franchise, because you want it all run through your company. And then you want your agreements, whatever contracts there are, the franchise agreement itself, to be in the name of the company. The bank will very likely require you to sign a personal guarantee in that situation.
Right.
Simply because you have a new LLC that, as of this moment, owns nothing.
Right.
But, so that's typical. But it still provides you a protection from everybody else.
Right.
The bank might come after you, but,
Right.
if you pay your bills, it all works out good, you'll be okay.
Yes.
And then I would suggest having somebody review the franchise agreement. If you're going to be leasing space, have somebody review the lease before signing it, just to make sure that, not necessarily negotiate, although that can certainly take place in terms of the lease maybe. Franchise agreements are rarely negotiable,
Okay.
simply because the franchisor wants everyone to have the same set of terms and conditions, so that if something happens at one, they don't have to specifically flip through that agreement and say, oh, well, was Joe allowed to do that? Or, did we give him special leniency in this particular situation? They want everyone's to be the same.
Okay.
But franchise agreements are hundreds of pages. So someone should read them, so that at the very least they can tell you where the red flags are and just things that you need to be aware of if you're supposed to do something at a certain period of time, or if you need to let them know about something. Shooting them a quick email isn't going to work as official notice. You have to send it certified mail to them and to their attorney and to this other place as well.
Right.
Things like that people don't, you're not thinking about, because, all right, I know how to run my business, but you're not thinking about maybe the legal side or the insurance side.
Never done it before. You don't know what you don't know.
Exactly.
Yeah.
Exactly.
And that's tough to pay for all that help in the beginning, because you don't have a business that's
Correct.
generating anything. If you're leaving a job, that's even more stress.
Correct.
But it's still important.
Yeah. It is important. It's kind of like doing a will, You're not dead yet. What do you need it for? But it's for protecting you and your family and everything you're building, trying to build, everything you have built
Right.
in the future.
One of my favorite phrases is an ounce of prevention is worth a pound of cure.
Yes, that's exactly right.
Some people get it. Some people, you learn two ways, right? You learn from others or you learn the hard way.
Exactly.
The hard lessons are the easiest ones to learn from, but they're the most challenging to navigate.
Yep. I would say a significant number of clients who reach out to me have come to me to do a will, for example, say, look, I just handled my mom's estate. She passed away.
Yeah.
I'm not doing that again. I'm not putting
I
that
wasn't
on
sure.
someone else. Yeah, so those who have experienced the difficulties in navigating an estate administration without a will, those who have experienced going through a lawsuit because they own the rental property in their individual name. You don't want to have to learn that way. You can always prevent it from happening again in the future, but you don't want to go that route.
So shifting slightly to real estate.
Okay?
So, and we'll touch on it because most people watching this are probably not interested in or own commercial real estate. But I just want to speak about it real quick because the Get the Guac headquarters, commercial property, and I was interested how similar but different commercial property is from a regular residential purchase. There's a lot of structure, I guess, when it comes to the residential. The forms are pretty cookie cutter. The commercial side, you draw up the contract. And it's not like a Keller Williams or a XYZ brokerage have the forms. You make the contract and you can do whatever, and there's a due diligence period that you can back out at any time if you write it in. And what's the closing period? Whatever you want it to be. Do you want to lease back? There's a lot more options to it. Do you want to go through some of the differences between residential real estate transactions and commercial?
Sure. There are some similarities. You still have the buyer, the seller. You still have closing costs that are associated that the title company will pay. You still have a title company that's going to conduct the closing itself, give you an owner's policy of insurance, maybe a lender's policy of insurance. Transfer taxes are pretty much the same because it's based on the purchase price. So state transfer, county transfer, state recordation, and then your $65 to record the deed and another $65 to record the mortgage.
Okay.
So those are the similarities. The differences are in purchasing residential real estate. There are lots of Maryland laws and restrictions and even rules and guidelines on various disclosures. If I have a residential house that has a leak that you can't see because I recently painted my ceiling, I have to tell you about that.
Right.
Commercial property is more so, look, here it is. Figure it out, do your inspection. There are periods of due diligence that can be 45 days, 60 days, 120 days from the date the contract is signed to the end of that period. And you can get out of the contract for any reason whatsoever, or if it just, quote unquote, isn't going to work for what you want it to be.
Right.
Which means for no reason at all.
Right.
If you just have the heebie-jeebies or you get cold feet, you can get out of it.
Yep.
A residential contract, you really can't unless there is something significant. And even then, you have to give the seller an opportunity to address that issue. So
Right.
residential, you've got 10 days to hire an inspector. The inspector comes, it's really fast because within 5 days of the inspector coming, sometimes that period of time is a little bit flexible, but
Okay.
it's pretty much like 10 days to get the inspection. Once you have that report, you have 5 days to send a copy to the seller and say, here are the things that I want you to fix.
Right.
The seller can say, I'm fixing nothing, which then you can say, all right, I don't want the property.
Right.
The seller can say, I'll fix some things, but not all of them.
Right.
At which point you can say, okay, I'll take it, or no, I won't.
Right.
Or the seller will say, okay, no problem, I'll take care of all of those by closing. And then you're locked in.
Yeah.
You're stuck. So if the seller says they'll fix all of those things, even if you're like, ooh, I really don't like all of that.
I didn't really think they were going to do all that.
Exactly, because you have a list of 19 items. They said, we'll take care of all 19.
Right.
You're stuck.
Yeah.
And you got to just hope that the inspector caught everything, because a lot of times they don't.
Right.
And so with a commercial property, you've got this significant period of time to look at records, to have it inspected, to have a fire inspector, a roof inspector, an electrical, a plumbing guy come out. And it's a lot of money up front for property that you may decide not to purchase,
Right.
but that money is better spent up front than having a litany of problems after the fact that you didn't know about because you didn't do
Exponentially
the...
more expensive.
Exactly. You don't want to buy a 500,000-foot commercial building that needs a brand new roof, or
Yeah.
that needs a replacement of the entire plumbing system. So you have these inspections done, taken care of, and as a result, you see the commercial contracts fall through less and less because they have this period of time in which to get them done.
Right.
To get these inspections performed.
So now my franchise is doing well, growing. I need a space for my operations. I remember first hearing about this at the old office when I didn't have my own business, just my own practice. So I didn't deal with any of the lease negotiations back then. I thought it was interesting where if I want renovations done to the property, I can negotiate that with my landlord and maybe tack on an extra year or two onto my lease, and then they will cover X amount of dollars of the renovation costs.
Yep, absolutely. That is not uncommon for a landlord to kick in 100%, 60%,
Right.
70% of the cost of certain renovations. What you need to be very careful of is within the lease, there is typically a section that talks about alterations within the premises. If at any point alterations are performed by you or on your behalf within this premises, the landlord often retains the right at the end of the lease term to say leave it or put it back to where it was.
Oh,
And that can be incredibly costly. And everyone always thinks, hey, why would they want to put it back? Well, we don't know what they're doing with it after we're out of there. Perhaps they want to turn this, what was an office space with 50 different offices, into an enormous open gym. And they want gym equipment everywhere. So
Right.
they don't want all the walls up. They don't
Right.
need 5 bathrooms. They're going to have 1 locker room. So you don't know what's happening after the fact. So you just need to be aware of that. So you want to look for language, as an example, that says you are not required to remove any of the renovations that were performed
right.
during the lease term.
All right. Emily, as we're kind of winding down here, we're going to talk about a couple quick hit topics.
Sure.
Living will.
Okay. Living will, different than the last will and testament, and a lot of people refer to it as an advance directive. So they may have signed something with the hospital that says if they had surgery at some point in time, that says, I don't want to be kept on life support forever and ever and ever. But the hospital will still need somebody to say, okay, flip the switch or turn it off. Do I unplug or do I not?
Right.
So what the living will is, it's an appointment of an agent. The first page that we do talks about the qualifications, parameters of what I want the doctors to do. If I am in a coma, vegetative state, I'm not going to recover. Keep me comfortable, hydration, medication, food if necessary, but if the only reason I'm still breathing is because of this machine, turn it off. The next page is your designation of the agent, your healthcare agent who's going to be the one communicating with the doctors that says, yep, mom wants me to turn it off or she doesn't. And that person is going to have priority in visitation. The living will qualifies as a HIPAA waiver because that way the person can be fully informed and make a decision based on all of the facts and all of the information. They don't want the doctors to withhold something because of HIPAA.
Right.
So it also says whether or not you want to be a donor, and they have those individuals, the agents have the right to hire, fire doctors, consent to procedures, decline procedures. If you have a DNR, like a do not resuscitate, that would be in there as well.
Right.
And
These documents are really intended to make life easier, not for the person they apply to, but for the spouse, the kids, they're already dealing with a traumatic situation and then pressed with all of these decisions and trying to get into your head.
exactly.
Isn't this a way where everybody's
Yeah.
not in an elevated state of
Panic.
anxiety and panic?
Yep.
To say, hey, this was my intention when clear sound mind, so take the pressure off of pull the plug or not.
Exactly. That's 100% accurate. I mean, think about the last will and testament. What do you care? You're dead, The
What-
living will, if you're in a coma, you can't decide anyway, so.
What are some of the more, shall we say, interesting things you've seen included in final wishes for a will or estate?
Oh, I have had people leave assets to cats. I've had people leave funds in a separate trust to take care of their horses, pets, animals. I've seen them leave $1 to kids that were, not necessarily estranged, but they called them freeloaders or spoiled brats. So they said, here you go, here's my $1.
Man.
And they
Yeah.
leave everything else to charitable organizations, and their kids get $1.
Wow.
Those are some of the wilder terms. I have seen parents do wills where they specifically exclude a child, or they will have provisions that are not equally split between the children, and there's a sentence in there that says if anybody fights it, nobody gets anything, and it all goes to charity. Or if this person fights their share, they get 0.
That's a wild concept to me. I've got 3 kids. I go through painstaking detail to make sure if it's spaghetti and meatballs, each one has the exact same amount of meatballs. I cannot
Absolutely.
imagine the altercation if it was like $1 and then here's the, whatever's left.
Yes, and people say when they're living, oh, no problem, I'll make sure you're taken care of. But the second that money is sitting in front of them, they never do.
Money does really weird things to people.
And the less at stake, the worse people act about it.
Yep.
It's rare that you see people fighting over hundreds of millions of dollars. But, if there's $50,000 at stake, they're going to go to court and spend every last penny fighting about it.
What is a legal advice for folks that, and this is maybe getting into some of the litigation side of law, you have an altercation with your neighbor. What's your best first step if there's some type of conflict that you have with somebody before you call a lawyer?
Honestly, try to work it out with the neighbor.
Yeah.
Take the high road, be the better person.
Right.
Take one for the team and apologize.
Right.
Because even if you're right, and even if you hire a lawyer and you go to court and you win, you still have to live next to this guy.
Yeah.
And they could be there for another 20 years, as could you.
Yeah.
And it makes it awkward, And if you live out in the boonies in the middle of nowhere and there's 5 miles between you and the next guy, all right, maybe you want to call a lawyer earlier on.
Right.
But the best case is to always try to resolve it. I'll give you kind of an example, not necessarily on a fight with your neighbor, but in corporate transactions. A lot of times we'll be talking to our client and say, here are your legal issues, but then here are the business issues. They're not legal. There's no right or wrong way. So your best bet is to go talk to the other business guy on the other side in the transaction and see if you can come to some kind of agreement
Right.
on the terms, and then we can put them in the legal language that you need.
Maybe have a conversation and try to be above the situation and see it from the other side before you go lawyer up and get real
Yes.
strongly worded letters
Yes.
and so forth.
I would not send text messages. I would not send emails. I would knock on the door and say, can we have a quick conversation standing on your front porch?
If there is a conflict, I was given a piece of advice years ago. Joe, pretend everything you say is going to be on the front page of the New York Times.
Mm-hmm.
And usually when there's, let's say the 2 parties don't quite see things eye to eye, emotions run hot, potentially, and feelings get hurt, and you want to say what you want to say. But at the end of the day, what are you trying to accomplish, and what's going to help you towards that goal, and what's going to get in the way of it? And saying something in the moment that makes you feel better, that good feeling goes away, and then you're left with the residual effect of, whatever that comment or that thing.
Right.
And so I thought that was interesting. Everything you say, pretend that it's on the front page of the New York Times.
Yep.
I don't know if anybody reads the New York Times anymore or what.
That's a newspaper?
I think so. Now they're on these things called iPads.
Oh, fancy.
Behind paywalls.
Kids
So-
and your technology. Actually, the technology route is the scary part because people post things on Facebook, on Instagram, on, TikTok, and it's there. You can't take it away. It's up there. Someone's
Right.
going to screenshot it. Someone's going to forward it on to someone else, even if it's only up for 30 seconds. People stalk these social media outlets, and they're going to see it. They're going to find it. They're going to forward it on to their friends,
Yeah.
and it's so fast, and you can't take it back. Once you've said it, once you've put it on paper, so to speak, it's there.
It's
and
there
it
forever.
will 100% be brought back up if you end up in a court situation. So all of the
Right.
nasty things you texted your neighbor at 2 a.m., because they have to be up at 4 a.m. for work, that timestamp is going to be there.
Right.
The things that you said are going to be screenshotted, printed, and used as evidence. So
Yeah.
everything comes back. So stay out of your own way.
Right. People have a hard time with that.
That's the biggest challenge.
Yeah.
Convincing people that A, their money is probably better spent elsewhere, not on legal fees in a litigation matter,
Yeah.
and B, you're cutting off your nose to spite your face.
Right. So as we wrap up here, Emily, thank you so much. We covered a lot of big topics, but there's so many more that we didn't get to. If folks have questions, how do they get in touch with you and maybe have you help them with their legal, estate, other things?
Sure. Well, first of all, thank you so much for having me. There's two main ways to reach me. You can call my office. That number is 410-832-2112. That's my direct line. Or you can email me. It's Lashley, Lashley, at Whiteford, white like the color, Ford like the car, law.com.
Awesome.
So Lashley at whitefordlaw.com.
Thank you so much for coming in.
Thank you.
This was a blast.
This was great.
Awesome.
All right. Thank you.